Please be seated. Thank you for being here today. We are here for 1CA SA130285. It's State versus the Honorable Jury Bernstein, whom we're partying interest. Each side we have 20 minutes to argue, and petitioner, you may save time for rebuttal, but you have to watch your own time. We are recording the argument both in audio and video, and we put our arguments on YouTube. That takes a couple of days, so in a couple of days you'll be YouTube stars. We've read the briefs. We've conferenced the case. We've discussed it thoroughly. So keep that in mind when you present your argument. And counsel, you may begin.
Thank you, Your Honor. This is Lisa Marie Martin for the state of Arizona. This case at first blush appears to be confusing. The real parties in interest, which I'll refer to as the defendants here, have been very successful in making it confusing and confusing the respondent judge about what it was really all about. And what it is about is, are there errors that so skew the gas chromatograph, instrument number 2 at the Scottsdale Crime Lab, that it cannot produce reliable results? The defense has shown none of their results are inaccurate. Indeed, Commissioner Bernstein has found that no results were ever shown to be inaccurate. Not only none of the defendants, but no results, period. The issue here is of widespread importance, and that's why the state is asking the court to accept jurisdiction. We've had a few cases on the amended Rule 702, a couple that actually dealt with Rule 702D, but in those cases, it was said that Rule 702D didn't have to be applied in the case of a cold or a blind expert, and that it was liberally applied. Here we're actually looking at, did Commissioner Bernstein properly apply Rule 702D when he said that the methodologies were not properly or reliably applied to the facts of this case?
Counsel, I want no serious issues with this particular machine. It doesn't seem to always work as intended.
The machine doesn't seem to work as intended? Well, Your Honor, actually the record is contrary to that. The record shows that the data drops, as the defense calls them, or the failure to acquire data, shows there's really a timeout issue, an issue where there was supposed to be an electronic handshake between the GC and the headspace, and it didn't meet at that 10 seconds, so it stopped collecting data. It didn't report a result in that particular vial where that happened, and it was rerun. The manufacturer was contacted. They did a root cause analysis. They had done it actually for a previous customer at their own laboratory, Perk and Elmer, and had put in what was called a rapid remedy. It was put on, and the instances decreased. There were only 2 more instances after that. But in any event, they did not affect any analytical part of the equipment. And I think if you look over a 3-year period from 2009 to 2012 and say in all the categories of errors, including, a jammed vial or a crane getting out of position or human error, which obviously you're going to have sometimes, which is why you have replicate samples, controls, calibrators. Nothing is ever perfect, but none of these errors went to the analytical validity of any of these tests. And isn't that what expert testimony is about?
So let me follow up on that with you. I think in the briefs there's a reference to this specific instrument, which I think is referred to 2003 in some of the filings. as performing about 21,000 rough numbers, analysis of 21,000 samples over the past 3 years.
Injections.
Right. And your brief takes the position that, well, look, if you total up all the issues that defendants complain about, they're talking about 35 or 40 or 45, somewhere like that. What if, though, instead of 35 or 40, the number was 10,000? Would your argument be the same?
I think 10,000 is a lot higher number, but not only that, I would have to know what kind of errors were those 10,000.
Let me
if
help
there were-
you. Let me
okay, I'm
help you
sorry.
on that. What if they were errors that resulted in no data? And those are called various things: data drops, stops, interruptions. I mean, I'm trying to get beyond the dispute on what they should be called.
Well, if 10,000 errors resulted in no data, it's clear to me that they would have went back to Perkin-Elmer. Well, first of all, they would have went back to Perkin-Elmer long before.
Let me encourage you not to fight the hypo that way. What if
Okay.
instead there were 10,000 tests that resulted in no data? Would your argument, but 11,000 that resulted in data? Would your argument be the same?
I would still say it did not affect the reliability of the results. Clearly, it's not very cost efficient to have to keep doing that over and over again. But it's still, if you get no result, it's not a suspicious result.
So the same then under that analysis would apply if instead of 10,000 you got 20,000. Only 1,000 times did any data come from the machine. Your argument would be the same.
My argument would be that it still does not produce wrong results. But at some point, you're going to have, a machine that, is stopping all the time. That's not what we have here. I know you said don't go outside of it, but if a machine is stopping all the time, then I would say, yes, maybe that's something that Commissioner Bernstein should have been concerned about. But that never happened. It never got to this point. It never would have gotten to that point. I'm sorry, did I answer?
Please continue.
Okay. What I wanted to say is that in terms of Rule 702D, we can write on an Arizona, we, not me, you can write on a clean slate with 702D. We don't have to do everything the way that other courts have done interpreting Daubert. But our cases so far that have come out said, looking at the federal comments to the rule, to Rule 702, looking at cases interpreting 702D can be helpful and persuasive, but not binding. The amicus has also cited cases, and the state has cited cases that the rule has been when you have a generally accepted science, a gold standard science like gas chromatography, then you look at the application in terms of weight. Unless maybe it is something like you have, the whole lab, everybody loses their proficiency license. Every single test is taken to an independent lab by the defendants and shown that the result is, 10 points different. That's not something that has happened here, even close to happening here. In fact, none of them have one of them got their blood, Mr. Kelly, and took it somewhere and never told anybody about it. He doesn't have to, but what does that tell you?
Well, let me ask you about that. What should that tell the court? How can the court consider that, given that the question here is whether the state has made a prima facie showing by a preponderance of the evidence that the evidence you seek to admit is admissible? Well,
I think that, did you know you all are sitting in the wrong seat? I'm sorry. I was just looking at you because I was like, I will say his name, and I was going to say Judge Roscoe. I'm sorry.
And I apologize to Judge Roscoe for my sitting in the wrong spot.
You were on the previous panel in the case, in this case, in which it was a discovery dispute where the defense said, we need all the test results in the world for years from the Scottsdale Crime Lab before we have a hearing so that we can find out if it's reliable. And in the order granting the state relief from that far-ranging fishing expedition discovery, this court itself said that the most material issue as to accuracy is for them to get an independent test, and that none of them had done so.
I recall what we wrote, Counsel.
Okay. I think
But
it's
that was
definitely
That was a
relevant.
different issue.
Okay.
The question here today is not discovery, it's admissibility of evidence. And so let me ask you, how should this court, if at all, consider the fact that independent testing is available but apparently has not been done?
Well, the court should consider it, but the court has much more, even stronger to consider it, and that is all the safeguards that, and all the double checks, that the self-validating system of testing here, despite all of these instances that have happened. These
And
are
Counsel,
things like,
and I understand, I think you're going
Okay.
to get into, and I want to hear from you
Okay.
on
I'm
about
sorry.
what SCL does.
To consider it with that.
But the question that I have is with respect to the separate vial that's held in a freezer or on a shelf somewhere that could be tested by defendants, but on this record apparently has not been. You mentioned that in your brief. What relevance should this court give at all for that fact?
I think this court should give it high relevance, and I think this court should give extremely high relevance to the related fact that the court found that there have been no inaccuracies proven. And to me, I guess it's just self-evident that to say this is unreliable, producing results, the application of this science to these facts would be the application of doing a test by this gas chromatograph on these defendants is producing unreliable results. Isn't it not then relevant to know, when we have a chance to find out, does another result match that when we can easily find that out? Isn't that relevant that they have chosen not to do that?
Perhaps, and I appreciate that response, but you have not chosen to do that either. Is that correct? You have not had an independent laboratory test these challenged samples. Is that fair?
We feel, the Scottsdale Crime Lab and the state feels that it has not sent them to independent crime lab to test. We have met our burden of proof, whether it's the preponderance of the evidence, which the Commissioner Bernstein now says the standard that he used, or clear and convincing, for this evidence to be admissible. This is a gas chromatograph, one of the machines that we do the testing on, and this could affect other cases. We should not have to go and get an independent test to show that.
Counsel, let me ask you, I had interrupted you, I think,
Oh,
when you
and
were
I'm
about
sorry.
ready to talk about checks and other mechanisms within SCL as opposed to outside of SCL.
Oh, okay. Yes. And these are replicate vials for each subject. That means that in the carousel that goes into the carousel for the GC, each subject sample already has a duplicate right in there, and they have to match plus or minus 5%, or else they are not considered acceptable. There's an internal standard put in every sample, and that's something called N-propanol, which is something like alcohol, but it's not alcohol, but it's put in every sample in the same amounts to try to guard against any small variables in the transfer process. There's calibrators, which are 4 known alcohol or ethanol concentrations from 0.02 to 0.4, which hopefully nobody would be above that, although we may have some people close to that. And then a blank after the highest ethanol to demonstrate no carryover between the pipetting and the analysis. There are 14 quality control samples throughout the carousel. The calibration curve with these different concentrations, it's called a curve, but it's actually supposed to be linear. So if you have from the smallest amount to the largest amount, then you get all these unknowns in there, and the controls come out, the calibrators come out correct, what they are, what we know we put in, then that is an assurance that what's in there is correct. Now, none of that was all testified to, and none of that was disputed. We again had, well, on some other instances, this machine stopped on certain things. They acknowledged that someone came out and fixed it, but that it happened again. But much of the judge's ruling, or the commissioner's ruling, excuse me, is actually not supported by the record and is internally inconsistent. And this court does not have to defer when the facts are not supported by the record, and when you have a de novo issue here of Rule 702D and the application of it. Now, obviously, there are roles for a gatekeeper. We're not saying that the judge can't be a gatekeeper. Under Rule 104A, which is what this test is done under, the preliminary findings, the judge was always a screener. It was a screen. Now it's a gate. But with Commissioner Bernstein, it was sort of like on The Wizard of Oz, where they're like knocking on the door and saying, "Can we see the wizard?" And he's like, "No, you can't. No, you can't see the wizard."
Counsel, let me ask you this. You agree, though, that the 702 standard that came into place 1st of January 2012 is a different standard. It's a fundamentally different standard than the law before that, correct?
Actually, I don't think it's fundamentally different, and I don't think it was intended to be fundamentally different. I believe that it was intended not to be a sea change in evidence, and it was not intended to subvert the adversary system. That's what we said when we adopted it.
And I understand the reference to the adversarial
Okay.
system, but it's a different standard. You agree?
Well, it adds 3 subsections it definitely adds 3 subsections in terms of the gatekeeper standard. So it's different. I would not say fundamentally different, however. I would not agree with fundamentally different.
I thought I heard you say that it adopted a gatekeeper standard, which was not part of evidence law under 702 prior to that time. Is that fair?
Well, what I said was that I thought a screen was similar to a gatekeeping, but obviously it has other prongs.
Let me ask you one other question, then I'll promise to try to be a little quieter. Tell me about the minute entry focused a fair bit about the ASCLD Lab International and the ISO certification. I would like to hear from you on that point as well.
Okay. The Scottsdale Crime Lab is certified under, and I'm sorry, I at one point had this written out in case I was supposed to say what it meant, but I don't have that written out actually in front of me. Oh, actually, American Society of Crime Lab Directors Lab Accreditation Board. The Scottsdale Crime Lab had previously been, I think since the mid-2000s, accredited under a legacy program. And then actually there was now the ISO is the International Organization for Standardization. And that has something called ISO 17025 that basically, my understanding of it, and I'm sorry if this probably isn't the best explanation, is that people that are working towards getting that ISO certification would try to comply with ISO, and it may require more rigorous document keeping, different measurements of uncertainty or whatever. That's my understanding of it. But at the end of 2011, after going through application process, site visits, the Scottsdale Crime Lab was accredited under the ISO standard. And there was, okay, I look like you're going to ask a question, so I don't want to interrupt you already.
It seemed to me that there was testimony disputing whether SCL was ASCLD Lab International compliant, even though it was certified, I think, in the middle of 2011. And the testimony from at least one, perhaps two of the defendant or the experts for defendants sort of expressed doubt about that, and I wanted to hear from you on that.
I can tell you a little bit about that testimony. Mr. Chester Flaxmeyer, who had only read about ASCLD in the public domain and had never been in a laboratory himself that had been ASCLD certified, said that it was his understanding that only a few cases were looked at, some representative cases. So he said, and I mean this is probably a matter of common sense, that if they don't see everything, there may be something that they don't see that is wrong. And so he tied that in to the rest of his testimony, that I think there are things wrong, and I don't think that I don't see how they could be certified. Part of this uncertified thing, though, also, or why they shouldn't be certified, part of that testimony went to the what do they call them, the mixtures and things that they were using, whether they were qualified and whether they kept their batches of mixtures that they put in, whether they kept them too long. And the judge finally decided in his order that that was all going to go to weight. So a lot of them talked about, I don't understand. Flaxmeyer talked a lot about, I don't understand how they could be qualified when they're leaving this mixture out too long. Mr. Lonnie Dworkin, who was the software expert who got his expertise for this case from looking at the Perkin-Elmer website and looking at depositions, he actually said that the Scottsdale Crime Lab, what he said is it met ISO standards if an instrument was worked on or a root cause analysis was done at the manufacturer on comparable equipment. And he actually gave testimony that was very favorable to the state in terms of that he respected Perkin-Elmer from what he had read on the website about them, that he thought they were a good company, that they were the best to know how to repair anything that was, any time out issue, and that if they said it was vetted, it was vetted, and that was compliant with ISO 17025 or 17025. I'm sorry, I only have 7 seconds.
Thank you.
Thank you.
May it please the court, my name is Joe St. Louis. I'm here with Lawrence Koplow, Cliff Gerard, and Mark Dubiel, and various other people. We represent the real parties in interest. As I understand it, we're here today to help you decide whether you're going to take jurisdiction of this issue, whether you're going to take it up. And the state has espoused, I think, 4 basic reasons that they're arguing to you are why they should be taking that. The first one that was cited by the state is that it's a matter of first impression. But I've got to tell you, I've read at least 3 opinions from our Court of Appeals on Daubert issues since 702 went into effect, and so it's not that the courts need guidance in general on this new rule. The second argument that's being espoused is that this is a matter of statewide concern. And while this certainly may affect other people, this ruling may affect other people in Scottsdale, it's not an issue that applies from one lab to the other. As you know from Judge Bernstein's order, this is very, very specific as to a piece of equipment that was repeatedly malfunctioning and a laboratory that never determined why that was and corrected it and continued to use it. Although I read in the paper it's no longer being used. And so it's not that this is an issue that the ruling is going to be used to get rid of blood tests coming out of the Department of Public Safety or Chandler or Mesa or someone else. It's very specific to this laboratory. It's very specific to these people. The state is also arguing that, well, there are likely to be conflicting decisions on this issue. I'm not sure where that's going to come from. It took an army to put on a 17-day Daubert hearing. One of the state's arguments originally was, well, we'll be seeing this all the time. And the resources that were required to get this together are pretty unique. So it's hard to imagine that occurring again. And finally, they're arguing that the state has no right to appeal, and so you ought to go ahead and visit this issue. And sort of when we get there, we get into the merits, I guess, which is, are they likely to win on the argument?
Do you agree that they don't have a remedy by appeal?
I think that is correct, Judge Orozco. We did research that. We came to the same conclusion. It's got to be a constitutional basis for suppression for the state to have a right to appeal.
Well, careful. Getting to the merits, what I found striking about the judge's order was just, even taking into account all of his findings regarding the errors in the operation of the machine, he said that in your collective clients' cases, those tests were not invalid. If that's the case, then doesn't much of the force of your argument go away?
No, and I'll tell you why not true. We're doing a Daubert hearing here, and as you know, a Daubert hearing doesn't deal with the accuracy of the results. That's not what you're looking at. You're looking at were there trustworthy methodologies employed as they were applied in this case. Do they give us an assurance that we're going to have trustworthy results? When we talk about headspace gas chromatography as an accepted method of testing blood for alcohol, there's an assumption there that you're going to be doing it on measuring equipment that is capable of producing accurate results.
And it seemed to me, at least by my reading of the record in the order, at least in the specific instances that we're dealing with, that occurred.
Well, the problem, Your Honor, is we sort of never get there. We sort of never get there because we have to start off with a machine that we know is working in the first place. We have headspace gas chromatography, that's fine. We have certain procedures that we follow, that's fine. But if the machine isn't working, if we don't know that when we add 2 plus 2, the answer is going to be 4 on that machine, we can't rely on the results for anybody's test. We never get to accuracy because the way that we're making that computation isn't trustworthy.
And that's true even if the computation, instead of saying 5, to use your hypo, says NA.
Yes, Judge. Anytime that you're using a piece of measuring equipment, you get an unexpected result. What you need to do, ISO says this, ASCLD Lab says this, you pull it out of service, you find out what the problem is, you fix the problem, and you do this root cause analysis so that you know you have taken care of the problem, and then you can start using it again.
So even if, I think, I've always thought that sort of false positives are sort of the largest enemy in bad testing. There's no suggestion that the data blanks or gaps result in that. They result in nothing, right?
The data drops result in no collection of evidence. I absolutely agree with you. That wasn't all we saw in this case, as I'm sure you know. It sounds like you've done your homework from the questions.
We've read your papers, and I understand from your perspective that that's not the only issue that you raised during the 17-day hearing, but that was one, and it was one that you raised substantially.
Sure. I agree with you.
And that resulted in sort of no data, and it was clear that there was no data. In other words, somebody wouldn't misinterpret a data drop as being somebody blowing a .25. Fair?
I agree with you.
Let me ask, if we were in the pre-January 1, 2012 world, and if the evidence here was perceived as novel scientific evidence, which, are both hypotheticals. One, we need to go in the Wayback Machine, and the other, just accept my hypo. This evidence would be admissible subject to a proper foundation. Do you agree?
I don't think that the evidence would be admissible because I don't think we get to a point where a judge could say that it's reliable enough that it comes in and it's a question of weight.
Well, and the reason why I say that, because that in the Fry world, the focus on novel scientific evidence was, and this comes from Bible, again, looking way back, if it's generally accepted in the relevant scientific community, subject to a proper foundational showing, it comes in, novel scientific evidence. There are findings, at least as I read the minute entry, that this is generally accepted, this science is generally accepted in the relevant scientific community. So then under the old law, as I see it, it would come to foundation. Could the foundation be shown? And that's why I asked the question.
I think you're right, but part of the foundation would be under the Fry standard that you've got to show that you properly applied the techniques, sort of subsection D. I mean, I
Let
really
me
do
ask you
think it's
maybe a
in-
better question.
Okay.
Do you view the changes in the rules January 1, 2012, and by the rules I mean Rule 702,
Yes, sir.
as a change or as no change?
Oh, I view it as a change. It certainly, I think, expands the judge's role and probably clarifies what a judge needs to do as a gatekeeper. I do think it gives additional duties. Having said that, I also think it doesn't change the outcome in this case, where you've got a machine that's this bad and we don't know why it's creating the errors and we can't trust the results are what they're supposed to be. It wouldn't have come in under Fry anyway.
Please continue.
Okay. Judge, I want you to understand that the state is talking about, actually, I should probably go in order. The state has not provided you with one case in which the finding of a trial court was reversed as an abuse of discretion. In every single case, the prevailing party was upheld by the appellate court. There wasn't a case that cited that where they said, no, the judge abused his discretion here. There isn't one case that deals with a malfunctioning piece of equipment that has not been pulled out of service and repaired. And there isn't one case in which a judge made findings regarding the credibility of the witnesses.
Let me ask you about that.
Sure.
And you pressed that in your response to the petition.
We did.
Would it be proper in determining the admissibility of scientific evidence for a court to look at and hear face-to-face, look in the eye of the expert and say, I don't think you're credible, I'm going to exclude you? In other words, is credibility assessment proper in doing the Daubert analysis?
Maybe, I don't know. I haven't gone down the road of how far that would go. I think that it was proper in this case, Your Honor, because we had written statements from the witnesses that directly contradicted what they were saying. We have specific findings by Judge Bernstein that Ms. Valdez and Ms. Whitman, that their lack of candor in their testimony was incredible, is the word he used on page 15, and troubling as to Ms. Whitman is the word that he used on page 14.
I thought he then went on to say, though, that he was not making his decision based on credibility. Perhaps I misrecall that.
I didn't, I'm not remembering that. If you can direct me to where that is, I'm not sure.
The question, the broader question that I have, and
Yeah.
I think you raise it largely in in arguing that this court should decline jurisdiction, let me see if I can get you that site. It strikes me that if it really is a credibility determination, that's an enormous change from how the rules of evidence have worked previously and, frankly, how trials work, where the jury, the finder of fact, makes credibility determinations, not the court in determining whether expert testimony is admissible. In other words, the comment to the rule clearly says, look, competing experts can be admissible. Just because they disagree doesn't mean it doesn't come in. And I guess the question I have is whether it is proper under this new rule for a court to base an admissibility determination under 702 based on perceptions of credibility, if in fact that's what the commissioner did, and the minute entry at 19, at least from my notes, suggested that he didn't.
All right.
But that's a general cite to a full page, and I don't have a specific quote to you. But the broader question I have is, legally, is that appropriate for a court to do? And if so, are there cases saying that?
I don't have any cases to cite to you, I can tell you that. But I think that a trial court has to, when making any determination, has to look at the credibility of the witnesses testifying. And we're not talking about, the state wants to turn this into, well, they disagree, there's a battle of the experts going on here. And Judge Bernstein is clear in his order that he doesn't see it as a battle of the experts.
In fact, he disavows reliance on your experts, as
he does.
I recall.
Yeah, he certainly does. I've lost my train of thought. We're talking about
About credibility and whether it's
Okay.
right. Now, if you're right on that point, wouldn't that indicate that you'd always have to have a Daubert hearing anytime any evidence is changed, which is not the law? In other words, how could you make that, if you can properly assess credibility, how can you make that on written submissions? How can you make that call?
I understand what you're saying, Judge. Here's where I think we are on this. I think that if the credibility is, I don't believe this expert when he says that he thinks the results are expert, that's not a proper, I'm sorry, that he thinks that the results are accurate, that's not a proper role for a trial judge. But when we have this, plethora of errors, and there's an explanation that's being given, and at the same time that the expert is saying this is not a problem, they are writing to the manufacturer and saying, we have a problem that we cannot correct. We need you to create new software for us. I don't see how a trial judge could not take that into account. I can't see how he would disregard that.
Cancel if there were simply one error with the machine. I think that would not show that the machine is not reliable for this purpose, and that might be brought out on cross-examination.
It does depend on what the error is, Judge. There could be an error that is so large that it would require the machine to be taken out of service under ISO standards, under ASCLD standards. That certainly is not our case. One of the things that Judge Bernstein relied upon was the fact that this went on for years. At no point did they ever, turn off the conveyor belt to see what was going on and fix it. Most likely not. Most likely probably one error wouldn't cause that, but it depends on the magnitude of the error. The state I'm sorry.
Then
Please.
where is the dividing line between admissibility and just having it criticized under cross-examination and unreliability and exclusion?
It comes down to whether or not the results are trustworthy, Judge, and sort of the way that we determine that is, did the analyst make an error? Did he put too many drops of blood in one of the vials and get a wrong result? That's not going to, in one of the blood runs, that's not going to result in exclusion. But is it a machine error? Is it an error that affects the results? And I think it's important that the court understand, when we talk about the results we get, and this is from Exhibit 5, the third page is an example of chromatograms. This is what everybody relies on, what's printed out. This is what the analysts look at. They look at it, they say it looks good, and they prepare these summary charts, which is the first page of Exhibit 5. And so, when they come up with this 30 out of 21,000, they're talking about, we went back and looked at these sheets and we didn't see in these runs where the analyst noted that there was a problem.
If the machine, when the machine works properly, does it give accurate results?
From a scientific point of view, as Mr. Flaxmeyer testified and as Ms. Arvizu testified, we can't say. When Mr. Flaxmeyer says, I can't tell you these results are accurate, he's saying no one can tell you from a scientific perspective, because we don't understand when the machine does make mistakes, why it's doing that. And as Ms. Arvizu says, we don't know what else is going on there. We can have silent errors. That's why we pull it out of service. That's why we find out what's going on. Until we've done that, we cannot say, yes, some of these results are accurate because they look okay, others are not because on their face we can see they're wrong.
Counsel, let me ask you, I read the record as indicating that ASCLD Lab International, that the SCL was certified ASCLD Lab International compliant on the 2nd of June 2011. Is that how you have it?
Yeah, that's when ASCLD.
Now I understand there's testimony offered that suggested that perhaps that your view was different on whether that was actually in compliance, but ASCLD Lab International suggests compliance with the ISO 130285 2005, doesn't it? That's part of it, according to the certification. Somebody said it was compliant.
And let me tell you how they arrived at that. That statement is correct, Judge, and let me tell you how they arrived at that statement. It would be a little bit like this court was looking to see if someone was ineffective at trial. And so you had a checklist, and you said, okay, the lawyer gave an opening statement. The lawyer asked at least 3 questions of a witness. The lawyer gave a closing statement. All these things are checked. Doesn't tell us anything about the quality of the work, but it gives us more information. That's what ASCLD Lab does.
And I understand your perspective on that. And there's a window before certification is granted of at least 6 months, right, where ASCLD Lab International sort of kicks the tires, if you will, in a selective way, not a comprehensive way, but a selective way. Is that your understanding of how ASCLD Lab International certification works?
Not really. What they do, Judge, is they make sure that what you're describing is kicking the tires. They make sure there's paperwork that's sent back and forth. They say, we want to make sure you have written procedures for all of these. We want to make sure that if you're doing blood testing, you're specifying you're using a dual column gas chromatograph. That's what the process is. It's getting all the paperwork in place. The lab is given 6 months notice, hey, we're coming in to look, get your ducks in a row. We're going to be pulling 5, or we're going to allow you to pull 5 files, give them to us. We will go down our checklist and see if these comply.
So an audit, if you will, a limited audit, not
a very
comprehensive.
limited audit. Yes, Your Honor.
What are you aware, with respect to both ASCLD Lab International, but more specifically the ISO 1725-2005, of any cases excluding evidence based on a finding that a lab, for example, wasn't compliant with ISO 1725-2005?
I
have not found any, I'll tell you.
I think that's right. And just to try to get this in the last few seconds.
And I apologize.
That's
perhaps
okay.
our chief will grant the parties a little more time. But
ISO is a rulemaking body. What they do is they say, here are the minimum standards for scientifically reliable evidence. ASCLD voluntarily says, we will, rather than having the federal government come and inspect our labs, we will band together as crime lab directors, we will inspect our own labs, and the way we'll do it is through this audit. So there's no, they're supposed to be using ISO standards, but no one from ISO ever checks them to make sure, hey, you got everything that you were supposed to hear.
give me just a second.
Certainly.
Yes, that's fine. Counsel, if you would, if you would like to continue for 2 more minutes.
Let's let them put 2 more minutes on the clock
Yeah.
for each side.
Thank you.
Sorry.
And then we'll give the state an additional 2 minutes.
Of course, sir. The other thing that I should mention about ASCLD is they didn't report the errors that we have shown you to ASCLD. When they found the mistakes, when they found the data drops, they didn't send that to ASCLD and say, hey, this is what's going on. What it is, as I mentioned, there are 5 files that they're given for each analyst. If one of those files happened to have an error in it, then the ASCLD inspectors would know about that. Otherwise, they wouldn't. That was one of our complaints when we talk about the 31. That number grew during the hearing as we discovered an error file, which was called something else, a maintenance file that had a number of issues we had not seen. Then there were some non-conforming memos that came in at a later time. And then the emails that we've discussed brought even more errors in. That's kind of where we are. The one thing, you kind of addressed this, Judge Thumb, I guess I wanted to say something about it when they talk about there's this second vial of blood that's out there. The United States Supreme Court rejected that in Bull Cumming. In Bull Cumming, one of the state's arguments was, hey, if there's a problem with the blood test, then the state can bring in their own analysts to testify about that. And the United States Supreme Court was very clear, and I think this is in footnote 1, when they say that it's the state's burden. The state's burden to meet the evidence. And really we're talking about, do we have guilt by machine, where the state comes up with a number and the person is guilty unless they can produce a contrary number? Or is this just like any other piece of evidence where the state has the obligation of establishing the trustworthiness? If they show that, yeah, there are some problems, but they rise to the level of being shaky, which is probably the most inartful term in the world, then it's a matter of cross-examination. But if it goes to the trustworthiness of the results, and literally, if you look at that fake vial one, it's on pages 26 and 27 of our brief. I put it in there because I'm a visual person. When you can't look at the test results that are generated and tell what vial they are for or what measurement they're making, you don't ever get to accuracy. You don't get to admissibility. That's not a question for the experts. That's a fundamental problem with the test results, and they're not trustworthy.
Thank you, Ken, for your time.
Thank you, Your Honor.
Ms. Morgan.
Thank you. I appreciate the additional time. I would actually like to follow up on, after sitting there for a while, I thought of an answer to your question, Judge Thelma, on in terms of the independent test, what weight, or use the word weight, or what relevance should you give it? And in the comments to Federal Rule 702, when it talks about that this is not intended to be a sea change, Daubert wasn't intended to be a sea change, and the amendments to Rule 702 not intended to be a sea change, we're still going to rely on the conventional devices of vigorous cross-examination. And one of the things is presentation of other evidence. And that would be in cross-examination that the defense could use their independent results. So the fact that...
But it sounds like you're saying that the defendant has to affirmatively present evidence on this.
Not that they have to, but that it's something that should be considered in terms of whether they should be able to ask for exclusion and the court should order exclusion. And here, especially when there's no evidence of an inaccurate result, not only of these defendants, but of anyone, there is no evidence. And the defense attorney held up, this is what we rely on, holding up the chromatogram, or I think that's what he held up, I wasn't in front of it. But where the things misprinted or came out with a page that misprinted labels, or was a printing template that misprinted because of the data drop that caused it to misprint, those weren't some final reported result that someone were saying. I mean, yeah, they would, if it happened on their particular case, it would be disclosed to them. This happened, and then it was rerun, and they'd see that print out, but it wasn't the final reported result. Oh, here's your final reported result. That is not what happened. That is a misrepresentation. And going back a little bit to the ASCLD and the ISO. Oh, I'm sorry.
Counsel, your time is up.
Oh, how did I do 2 minutes and 6 seconds that quickly? They talk faster or slower than I thought.
Thank you, counsel. Thank you for your excellent arguments. We will take them under advisement. We are adjourned. Thank you.
Jill, I'm gonna take this up too. Okay, sir. Nice meeting you.
Oh, nice meeting you too.